Trent started with some thank yous, and I just want to add a couple because, of course, we need to thank the thanker. So Quentin and Pratik have put a ton of work into this event. Adriel Borshansky's put a lot of work into this event. Mo Griffin, as always, has put an enormous amount of work into this event. And I know the other ADR student orgs have also done a lot of work. So I want to just say thank you to them, without whom we wouldn't be here. So we have a fantastic panel today, and I know they're going to have a lot of really interesting insights to share. I'm going to start off with the first couple questions. We'll give folks a chance to kind of do a general lay of the land, and then we're going to open the floor to questions from you guys. So just to kick us off, what I'd love to do is to have folks share a little bit about the day-to-day of your work. So this is a somewhat complex question, right? I'm also going to ask you after this to describe a little bit about how you got where you are. But I want to qualify my first question to say that you can describe the substance of your work not only in the moment that you sit, but if there are places on your path that you've moved through where the substance of what you did feels interesting, I think that would be great to share as well. Okay? So how's that for a complex, non-question question? Can I invite you to kick us off?
Okay, thanks, and thanks for being here. Well, I work in a particular niche of the dispute resolution world. I mediate large, complex cases, high stakes, highly lawyered up, high profile, very complicated. It could be anything from a multi-party antitrust case, class actions, a lot of class actions, individual plaintiffs, state attorney generals against a dozen price fixers. It could be a complicated financial transaction involving residential mortgage-backed securities, derivatives, trustees for security holders, and the like. It could be a construction case. It could be Gillette Stadium, for example, that I mediated the construction disputes over. It could be intellectual property claims between Apple and the chip provider, US v. Microsoft, I mediated. It could be a dispute between Andre Agassi and his agent or business manager. It could be anything. It could be a huge environmental case with 1,000 potentially responsible parties and municipalities and citizens on the other side. So they're big, complex legal cases, usually elite lawyers involved. I don't do any pro se cases. I don't do any marriage cases. I don't do any labor relations cases. Elite lawyers who are experts in the law in their area, they do it full time. They're antitrust lawyers. They're securities lawyers. They're construction lawyers, and they're at the top of their game. The subject matter is incredibly complicated and esoteric. So I'm every day dealing with completely challenging new facts, situations, and lawyers who are at the top of their game. So for me, I think of what I do as I'm in a constant learning situation. Every day it's different. And these cases typically start out as 1 or 2 day mediations. Sometimes they start out as year-long mediations, but they're fast. They're in court usually, but not always. I've been mediating the Visa MasterCard interchange case now for like 8 years. We settled it once. It was approved by the district court, reversed by the Second Circuit. We're back in mediation. That's a huge case. Lately, I've been doing something a little different. Rather than mediating the cases, in the past few years, I've been appointed as the neutral monitor or special master in cases that were already settled. So I've been the monitor of the settlements between the Justice Department and Bank of America over residential mortgage-backed securities, in which they had to provide $7 billion worth of consumer relief. And then I was asked to do the same thing for Goldman Sachs' settlement with the DOJ and Morgan Stanley's. Most recently, I'm the special master in allocating hundreds of millions of dollars in settlements growing out of 10,000 death case involving dialysis treatment drugs, and I've been appointed the special master to distribute the $1 billion worth of Takata airbag funds. Takata pleaded guilty to a criminal plea, and they had to do $1 billion worth of restitution. So I'm allocating that. It's a neutral role, but it's not mediation in those roles. So every day I grab a stack of submissions and documents and try to read them and master them, and then try to figure out what the problem is with the dispute, and in every single case design a new solution. Usually it's a mediation-based solution to the problem, but every case is so complex it requires custom design, and then I implement. That's what I do.
Great. We know who to call when we enter thorny, complex situations we need some help in solving. Toby.
Okay.
Tell us a
So
little.
hi, folks. Hi, my name is Toby. I work for a nonprofit organization called the Consensus Building Institute. We often go by CBI. And we're a public policy dispute resolution organization. So there's, a little bit of a field around the country, a little bit of a mini industry of organizations like CBI that focus on dispute resolution in the public sphere. So most of our clients are could be foreign governments or international finance institutions or international organizations, the UN, the World Bank. We do domestic work with government agencies, municipalities. So we actually sometimes work with Ellie as well, so I'm really happy to see her again at EPA. And most of our work focuses on dispute resolution related to the built and natural environment. So you could imagine disputes that arise over environmental issues, a watershed restoration project that's going to flood certain properties. Or you could imagine disputes around transportation projects, a highway that's being built next to or through communities that are concerned about the impact. You could think about it on the international stage. Transmission lines being high voltage transmission lines being funded through the World Bank that are traveling over indigenous communities, and they're concerned about the public impact of those projects, and maybe they're protesting and halting the projects from moving forward. So we are brought in any number of capacities. Sometimes we're directly mediating a dispute, and typically those would be U.S.-based disputes. So I mentioned the watershed restoration project. That was a mediation that summarizes kind of a mediation that I was recently involved with, where a number of government agencies want to restore some wetlands that are going to flood a number of properties, including a fairly large landowner, business owner in the area that is concerned about the impacts and concerned about compensation. We also do dispute systems design. So working for the World Bank, we're helping them think through their social and environmental monitoring programs and compliance programs, and how to actually create a system that will kind of effectively take lessons learned and spread them throughout the World Bank system so that they're not making the same mistakes over and over again, or actually setting up a dialogue or mediation, helping to set up a dialogue or mediation in a country in South Asia where there are protests over World Bank funded projects that have had negative community impacts. And we also do capacity building. So a big piece of my work is often training organizations, agencies, international organizations around negotiation, around dispute resolution. Sometimes we'll help design a dispute system and then kind of train them in how to implement it and kind of the principles behind it. So it's a really fun job. We're working on really cool, I feel like, important issues. So, right now I'm working with the State Department to redesign their negotiation training curriculum for diplomats, which is really cool. I get to talk with ambassadors and other high-level diplomats around the world about what kind of training they think would be really helpful and help them in their job, and then help design and deliver that curriculum to them. sometimes we're doing much more kind of problem solving than strict dispute resolution, and facilitating conversations around that. So I recently facilitated a conversation among kind of people involved in the tech sector, who kind of had been kind of successful entrepreneurs or kind of involved at younger, but also entrepreneurs that were successful, and interested though in thinking about what is the impact of technology that's coming out of Silicon Valley and elsewhere on work, the future of work, on disenfranchisement of workers in the U.S. and Europe, and how can we actually create projects and innovations that will help address that challenging future and those challenging impacts, and do something positive, kind of using the innovative spirit coming out of Silicon Valley. So we facilitated a conversation around how to bring innovative projects in this domain, and actually had folks come up with demonstration projects to try to address the future of work and future unemployment due to automation, et cetera. So my day-to-day work, it's often, I'm often on the phone with people kind of doing a conflict assessment, where I'm kind of hearing their perspective about what's been happening in their organization or with relation to a particular situation that they're involved that's kind of either filled with conflict or challenging in terms of problem solving. Or I'll be designing a workshop or a training, or deciding on the agenda for a conference that I might be facilitating on a particular topic. Or I might be just writing a report coming out of one of those. So, or I might be on the ground doing one of those things, actually facilitating or mediating and traveling to go do that. So it's a lot of fun. It's a real variety of work. I think the coolest part about it in my mind is you just get to hear and learn about these situations from all different sides. It's pretty different from being an attorney. I was an attorney in a previous life, where you're just focused on your side. And this side, you kind of get engrossed in that, but then flip over to the other side and get engrossed in their world, and then just have your mind blown. Like, wow, 2 different worlds. Then you talk to someone else, and all of a sudden it's 3 and 4. So it's really fascinating, and I love it, and I'm happy to talk to you more about it. Thanks.
Thanks, Toby.
Hi, I'm Ellie Tonkin, and I have the pleasure to overlap with people like Eric and like Toby in my role, and I hope you all find your way to work that is as interesting as it sounds like the 3 of ours is. I see the role of our program inside of EPA as helping people talk to each other about environmental issues, and that can take a lot of different forms. It might be a ripe dispute that's in litigation, that's a very high-level, huge, multi-party, thousands of potentially responsible parties kind of case, like the one Eric talked about. And for a case like that, we would help parties find people like Eric. I might conduct the mini mediation of helping a large group of parties figure out whether they'd like to pursue some kind of neutral assisted process. If so, what kind of neutral they're looking for, and then help them jointly perhaps interview some candidates and deliberate over who they can agree on by consensus. And we've never had a case where parties who are completely at each other's throats couldn't reach a real consensus, not a reluctant one, on who was the right candidate for them, because mediators are really starting to mediate when they're in interviews, and they're very good at persuading parties that they might be able to help them. In a lot of other cases, so a big, intensive case like that is the kind of case we would never have the resources to manage ourselves. But much to my surprise, a huge amount of our work is actually providing direct mediation and facilitation services. I'd say more facilitation. In the culture that I work in, a lot of people are freaked out by the term mediation. It sounds too much like somebody pushing you to do what you don't think is in your interest to do. And facilitation sounds like somebody, writing in colored markers on butcher paper on the wall and telling you that, you have 10 more minutes to talk, and could you wrap it up? And so in a particular situation, they know exactly what the neutral is doing, and they've elected to work with you because they're comfortable with the role that you're playing. But I've been in situations where the parties are unequivocally in a mediation with separate caucuses and drafting agreements, and one of them will say, so maybe we don't need to pursue mediation in this case, maybe we've been able to, and so the terminology can be funny and becomes quite smeared, and we're happy to call a process whatever parties want to call it, so long as we're being transparent about what we're doing. So I am that oxymoron and agency neutral in many situations, and that's a slightly different role from an outside neutral. There are things that we wouldn't do as in-house neutrals. We wouldn't offer our opinions about the merits of a legal position, or we wouldn't tell parties what to do. We wouldn't be evaluative. We might be very assertive in helping the parties move forward or make decisions, but we wouldn't offer our own opinion. And there are times when that's precisely what parties want and need. More often than not, parties don't really understand how a more facilitative neutral can really help them until they've experienced it a little. So that's one of the challenges of this work, I think. And then there's a whole other body of more public consensus building kinds of cases where parties are trying to do something together. They're not necessarily in conflict, although there are many moments when they could be and will be, because they're trying to do something hard together and they come from different perspectives. But in those kinds of situations, trying to develop some kind of a collaborative effort to manage a watershed differently, we might reach out to somebody like Toby. We might be having some big event where we're bringing together a lot of people to try to address a particular challenge or problem solve, and we might have a lot of breakout sessions. And so I might put together a team of facilitators to work with somebody like Toby, and we would design the meeting together. Or in other situations, I would fully collaborate with an outside neutral, more of a consensus builder or more of a traditional mediator, depending on the situation, to develop and put on a training. So a quick snapshot of a couple of days I have coming ahead. Tomorrow, I will facilitate a meeting among about 12 federal agencies, all of whom have some natural resource management function. You wouldn't believe how many federal agencies have those. And the participants will all be either attorneys who work on tribal issues or tribal program coordinators, and we'll be talking about the different ways different agencies interpret their tribal trust responsibility and how they implement it. Are there good reasons for those differences that are based on their particular mission? Would it make more sense for them to be more consistent in their approaches? So I've been working for months with the people who are planning that meeting, and I think of a lot of what I do as mediative facilitation. That rather than think of what some of the parties might think of as a facilitation where I'm going to help them have a meeting that's not a fiasco, I'm thinking of it as a group of parties coming together to try to do something, each with their own interests or with their own mix of interests, and personal and organizational, and I'm trying to help manage those interests. So the mediator in me, when I'm helping them plan this meeting, would suggest to them that they should get input on developing this agenda from a range of parties, that they should make sure that the tribes don't find out about this meeting belatedly in a provocative way, but rather are invited to suggest what they think it would be helpful for these agencies to talk about. So that's the mediative role that I really think has evolved because of the background of most of us who do work in the kind of setting I'm in. We came to it through mediation, and the facilitation part sort of came later. And that's kind of how I see the Consensus Building Institute's role as well. And I particularly love collaborating with others in the field. I feel like we have something to contribute from our government perspective, and I always learn. I got my best training from working with and observing other mediators in the field. I have the luxury to watch a lot of mediators in this role, and I like to plagiarize them all the time.
That's being inspired by. I think it's a totally different concept. Great. So there's actually a lot of commonality, I think, there are different flavors, but one of the things that feels like a common thread running through is that you're all really engaging complexity, you're thinking a lot about process, you're doing a lot of work to try to unearth and uncover what interests are driving different parties at the table, and in some way the process that you're facilitating is helping things move from some level of chaos or complexity to some kind of structured coherence when it goes well, presumably. So what I'm curious about, I know I said I'd invite you to talk about your journeys. I've changed my mind. I'm not going to do that right now. What I am going to invite you each to do is to, wonderful. What I am going to invite you to do is to share your top 2 pieces of advice for the folks that you see sitting in front of you. So if you imagine sort of being back in this room, back at a point in time where you're making decisions about what your career is going to look like and are hopeful that you'll wind up doing something in the ADR space, it's obviously a lot less cut and dry than just submitting your resume and going through the ordinary, the sort of default firm process. So what advice would you give folks to, if they wanted to end up where you are, or if they wanted to end up doing ADR more broadly? And you can speak as the spirit moves you.
I'm still thinking my second piece of advice.
Well, you could share one and come back to share your second. We're flexible around the process.
Well, I would say don't think you can plan it out. So be wary of any advice you might hear from here. Careers, in my experience, are often serendipitous. And there is no career, there's no established career path to be a neutral in ADR, and not like in the law where you can become an assistant DA and then a DA, or you can become an associate in the law firm and then maybe move up. There is no such thing. There are no roles for entry. There are no entry-level jobs to speak of in dispute resolution. I'm a lone wolf when I operate. Maybe I have a co-mediator, maybe one other person from my firm. A few years ago, I helped pioneer the introduction of an ADR clerk, like a law clerk for a judge. Judges have law clerks. Why don't I have a clerk? And I get the best and the brightest every year or two, and be an opportunity for students. I think I have a better docket than anybody else in the United States because I don't have to take the 300 run-of-the-mill cases that a federal judge has to take. I've got a great docket, so it'll be a great idea. But so my first one, who I was going to hire for a year or two, is still there 6 years later. Okay, he didn't want to leave. I didn't want him to leave. So there goes that. So my advice to you. Would be to, if you're a law student here, most of you law students here, or at MIT students, I would say pursue what you're studying in the professional world afterwards for at least a few years and become good at it and learn what that world is all about. So you have mastered from the ground and from the inside that which you've already been trained for. During that time, if you're interested in ADR, try to get involved in mediations and other forms of ADR projects, either at the place you're employed, if they have such opportunities, or if you can do extra things, pro bono, volunteer. I did so many things pro bono as a young lawyer in the ADR field, and would just like the opportunity to have the experiences. I would have paid to be able to do things I did pro bono. And so I think you need to be opportunistic within your more established professional routines, and you'll gain experience, you'll gain insight. If you do have an aptitude in this area, people will notice, and you'll be surprised. People will ask you to help solve this problem or that problem, and you will build a repertoire and a portfolio of successful involvements. And by the time you have achieved enough years so that people think you might have some seasoning and experience to occupy the role of a neutral, they'll look to you for that. And if those few openings in the dispute resolution world that do pop open, if you're really interested in those, apply for them and go after them. Somebody gets them. The problem is there just is not a broad path, career path, to be a neutral.
Okay, great. Thank you.
So I really agree with a lot of what you just said, and I think one thing I will say is there are some entry-level jobs in the field. I got one, so.
There's one.
Yeah. It's no longer there, I'm sorry. No. So, but I think, I'm trying to think like why did I get it? And I think there are a couple things. I was really invested, really knew what I wanted out of law school. I knew that I was interested in the field, so I pursued opportunities here. And then those, in turn, kind of opened up continuing opportunities after graduation. I think I spent a little time at a law firm, sort of taking your advice on that piece of at least getting your foot in the field that you're trained in, right? But in doing that, I always maintained connections to this world. So I stayed in touch with the people in my network that were here. I actually kind of took on extra work outside of my firm, doing ADR stuff. So I always kind of had a consistent chain of connection in this space, so that when the opportunity kind of came up, I could say, look, I've been doing this in all these ways for this number of years. And I think, totally you can't plan it. And so I think just sort of every step on the way, like as you go, just trying to find an opportunity that's going to bring you towards what you really want to do and not push you away from it. And it might not be, the final job where you want to spend your career, but it kind of gives you a skill or connects you with people that are the kind of people or the kind of skills that you want to be doing. And then as you build up enough of those, then you're going to get that credibility and you're going to have much more ability to actually make an affirmative choice on what you want to do. And another big piece that goes along with that is building your network. And people talk about networking like it's schmoozing at a party. I think networking is just meeting people through your work and doing an excellent job so that they want to work with you. And so do that and be excellent whenever you have an opportunity to do the kind of work that you're really interested in. And you will get a name for being good in that work. And then people will want to bring you in and want to hire you to do more of that work. So just a few pieces of advice for what it's worth.
Great. Thanks, Toby.
And I completely agree with everything that's been said. I work in a huge federal bureaucracy, and I basically wrote my own job description, do what I love, and am almost completely autonomous. And I just found a role that I didn't know existed, or that didn't exist. I'm guessing many, if not most of you, will end up in roles that maybe don't exist or have a name right now. That I think they're being generated even more quickly than they have been during our generation. I would say, sort of related to what Eric and Toby have said, if you want to be a mediator, act like a mediator all the time. Treat all your interactions like mediations, in the sense of, not in the sense of, what I hear you saying is you'd like to borrow my stapler, but but that you're listening, you're trying to help people, do what they're trying to do. You're trying to help people be clear about what their interests are. You're trying to help people make good decisions. And you're being a witness to the things nobody else is paying attention to. I actually think that's a lot of what I do. And the last thing that has served me well is when I first came to the EPA, it was a very irrational decision. It was consciously irrational. I interviewed with 4 people. It was to get interview practice. I had just decided I was ready to leave the private sector and was wanting to cast about for a public interest job, and I just, I happened to know that they were hiring at EPA. I thought it would be good interview practice. And I thought, these are the kind of people I'd like to work around. I'm a complete technophobe, and I'm constantly trying to persuade parties that I don't know what they're talking about, and they assume that I do because I'm an EPA employee. I think I'm actually at a stage in life where I've had some tough periods, and I work in a community of people that I just love being around. It is solo work. Unless you're working as part of a team, which is also very satisfying. Sometimes that's just not logistically feasible or sensible, and in that sense, it can be lonely work. And for someone of my temperament, it really matters to have a community of practice that is supportive and helpful emotionally and substantively, but also to have a place. I like having an organizational connection, a place where I go to work, and during those tough times in life, it feels like a warm bath. What made me make a significant change, there are only a few times when I felt like I took a real leap. Most changes were more incremental, the way Eric described. But I took one of those leaps because I felt like the people I was working around weren't people I really admired, that I didn't want to be like any of them when I grew up. And I took a job based on the intuition that these were the kind of people who would elevate me, who would applaud me for the right things. And in retrospect, that was of all the different career choices I made, that was the wisest one. So I guess I'd suggest that that's something you maybe consider.
Wow. Great. I am mindful of the time, and I want to make sure that we have time for folks to ask questions. I also just want to call your attention, so you may have noticed in front of you, you have panel biographies, but what you also have are some resources around ADR career planning, many of which come from the HNMCP website. But if you look, there are a couple of different places to look if you're job hunting, if you're looking for internships and fellowships, places where you can start out and be excellent and figure out whether they elevate you, and kind of follow the path. But also, I think good things to be aware of in terms of making initial connections and learning more also about what other people do. But what I want to do now, because I think my understanding is we need to vacate this room at 12:45. So what quick and targeted questions do folks have? I know that's a high bar. Yes, Kelsey.
I would to hear from each of you. I think Ms. Tomlinson spoke to it a bit, but what your mediation model is, and how comfortable you feel with giving suggestions about substance or making decisions. Just all three of you.
Well, kinds of cases I do. There's the distinction between facilitative and evaluative mediation doesn't exist. Okay, I'm involved in lawyered up, complicated disputes. People are well represented, and they want a lawyer's lawyer usually as the mediator. And so it's always a mixture of doing what a mediator does that people would describe as facilitative. There's a lot of that work that has to be done every time. And in my line of work, there's always a lot of talking about the no agreement alternative, which is generally the outcome of a lawsuit or some other more complicated procedure. And inevitably, they want to know what I think about it, okay? But it's how you do that and when you do it and how well you listen and how you deliver it that really is important. Every single mediation I do, I have to try to determine exactly, I say to myself, how active and how restrained the parties want me to be. And that's tough in every case, because lots of times they don't really know. They haven't thought it through closely, and they may not agree on that. But trying to figure that out and to provide to the parties what they want and what they need is part of the deep process challenge in every single mediation. I watched the debate for 35 years between the facilitators and the evaluators, and I think it's a bogus debate.
Ooh, intriguing. We're gonna put a pin in that. Toby.
Yeah, so I think...
I'll meet you outside.
All
You
right.
might have backup.
I think generally the skills that we draw on, the baseline skills, are from facilitative mediation. I mean, just being facilitative, listening, reframing, all of that. And I also think we tailor the tools that we bring based on what the situation demands. I think a lot like Eric is saying, sometimes we'll be talking about a particular client and situation and just be brainstorming among ourselves like, gosh, there's this tool from narrative mediation that I read about. I think that could really be helpful here. We should think about how to deploy that, or, maybe we really just need to put some idea out there that they'll reject and get their mind spinning that way, right? So it really depends on the context. And I think the baseline, the skills that we are kind of known for and best at doing are facilitative.
Thanks.
So I would say in most of my work, I mix and match a kind of community-based mediation model, sort of party-directed, do some kind of an assessment where you get input from all the parties, engage them in developing the agenda. I think, there'd be a lot of overlap in the ways that we do things, but in the kinds of cases that Eric works on that are heavily lawyered, there is a different place for giving parties a legal opinion or answering the question, what do you think, what do you think I should do? I certainly think that there are contexts in which that's very useful and exactly what the parties want and need. But in most situations that I'm involved in, parties also say, what do you think? I just would answer it differently, and I think it's appropriate to answer it differently in those situations. And I do think there are situations where the parties relying more heavily on, parties are sometimes reluctant to take ownership over their decisions, and I think in those situations it can be helpful to withhold your opinions. But it's very contextual, and I don't disagree that there's a place for that. I think, except when I'm working, I think lawyers like to know that I'm a lawyer. It makes them feel more comfortable that I can understand where they're coming from or the legal context of the case. Other parties are happy to not know that I'm a lawyer, and I don't think that what I do. I think being a lawyer is very useful to me in that it gives me an entree into a lot of situations, and it gives parties confidence in me. I think it has very little to do with what I do now and how I help parties. I don't regret for a moment that I got a law degree because of the ways it's helped me. I think almost anything you can do, and any job that you take is going to help you be a better mediator in some way or another that may be hard to quantify, but.
Great. A lot to follow up on there too, and I want to check in, Quint, am I right that what we should do is officially close and invite people to come up and ask questions informally? You know what I'm going to do, folks? I'm going to officially close, and I'm going to invite people to come up informally. But thank you so much. Thanks to our panelists.